Well, thanks for coming on to your own podcast, Chris.
Yeah, thanks for having me on our
You're
inaugural
welcome.
podcast.
So we titled this collectively as a group, It's Personal. Can you tell me what that means to you? Why is that kind of a double entendre in this case?
It's a double entendre because obviously we focus on personal injury law. So, we're handling cases where people have gone through catastrophic injuries, wrongful death cases, just any type of injury situation that has unfortunately befallen them, right? And so with that comes the personal interest that I have and my partner Alan Ahdoot have in representing people and standing up on behalf of people who wouldn't have the ability to fight for themselves, who wouldn't have the specialized knowledge to go up against insurance companies or large corporations, et cetera. And so for us, it's personal because we really believe in what we do. We believe in, again, fighting on behalf of the little guy. And that's something that for me and Alan is just, it's kind of innate. It's something that when we first partnered up in March 2010, we kind of had this unspoken understanding that we wanted to get into this industry so we could represent people who wouldn't be able to fight for themselves, who wouldn't have the means to fight for themselves, who don't necessarily have the money to fight for themselves, because on the other side of our cases are large insurance companies, large corporations who oftentimes have access to unlimited amounts of money. The average client we represent is, a regular blue collar worker working day to day, hourly employee. And so they don't have extra cash sitting around to pay an attorney a flat retainer or pay, out of pocket to retain an attorney to represent them in a standard personal injury case like an auto collision case or premises liability or a workers' comp, what we call workers' comp crossover, where somebody gets injured on the job due to the third-party negligence of somebody else. So for us, it's always been very fulfilling and rewarding to be able to represent individuals and kind of, be a bulwark for them against the insurance companies and against the corporations who would really, without an attorney in our position representing people, these companies and insurance companies would kind of run roughshod over people. And that's not something that, sits well with me or Alan. And for us, in terms of our what drives us to continue in this business and what drove us to start in this business in the first place is the fact that we do take it personally, what we do on behalf of our clients.
So you've been doing this for now literally 15 years at Adamson Ahdoot. So it's kind of an anniversary.
Time has flown. Yeah. We're back with another episode of the It's Personal podcast. I'm Christopher Adamson.
This is personal injury. It is personal.
Okay, so I guess taking it back a little bit to introduction. So you co-founded Adamson Ahdoot with Alan Ahdoot.
Yes.
And you guys met.
We met in law school. So we actually we went to UCLA undergrad. We were there at the same time, go Bruins, but we didn't know each other because obviously UCLA is a huge school. There's a huge undergraduate student body, and we just never really crossed paths. And then I was there 98 to 02, so Alan was there around the same time. We both graduated UCLA 02, and then we ended up at Loyola Law School in Los Angeles from 02 to 05, and that's really that's where we met. The law school campus is downtown by the Staples Center, so it's a beautiful campus designed by Frank Gehry, who also designed the Walt Disney Center, the Walt Disney Music Center downtown. Yeah, he designed Loyola Law School, so it's a really cool campus. It's very colorful. If you're into architecture, you can drop by and check it out. And
Did you ever get to go to the Playa Vista campus?
No, because that's the undergraduate campus, and it's also very nice, obviously, in Playa Vista. Yeah. So that's one of the one of the perks of going to LMU undergrad is getting to go to that campus. And so for us, we were downtown near the Staples Center, which
but you made up for it with architecture.
It's not as nice, but yeah, we made up for it with the architecture. Also had some fantastic law school professors there, including Stan Goldman, my evidence professor, and then Lori Levinson, my criminal procedure professor, who actually kind of made her bones on court TV during the OJ trial as a correspondent. So some very well-credentialed professors have come out of Loyola Law School and are still there to this day. So I highly recommend Loyola. That's a shameless plug. They're not paying me for that. But yeah, we met in law school through another friend of ours named Bill, who's also a personal injury attorney. He was kind of the glue that held us together, because I met Alan through Bill. And then at that time, Bill had an apartment downtown by the law school. And so we would all go hang out together after school, and we would run down to the Popeyes chicken down there by the USC campus, because Bill went to USC undergrad. So he was familiar with that area. So it was kind of Bruins and Trojans coming together.
I love it. Unity. I don't want to linger too much on law school, but I do, as a huge fan of Legally Blonde, a few words on law school. Is it, because obviously we're doing a program now at Adamson Ahdoot, and just because I also did not do an introduction, I'm the social media director, which is why I'm wearing this nifty vest and not a button down. But we're doing a cool program where we're actually supporting future lawyers.
Correct.
Who are currently in law school.
Yes.
And I've been obviously speaking with a lot of them, and as we've been curating content for our pages to support like this next generation of lawyers, I've found it really interesting hearing just the nuances of their personal experiences in law school. I guess if you had any words of wisdom for students who are thinking about law school or maybe are in law school suffering right now, what would they be?
For anyone who's in law school suffering right now, I would say the end result is worth it. For us, we went to the day program, which is 3 years. At Loyola, they also have a night program. So there's people that go to the night program and do, I think it's 4 years or 5 years. So whether you're there in the day program, night program, full-time, part-time, I think you just got to remember to not lose sight of the end goal, right? Mm-hmm. Not lose sight of what it is that compelled you to go to law school in the first place, for the people who went there with a purpose, because when I was in law school, there were some people that were just kind of there passing time because, they graduated from undergrad. They didn't really know what they were going to do next. And so they just said, I'll go to law school and get a law degree and, hopefully become a lawyer and see what happens next. Right? Yeah. But, in LA, there's kind of dilettantes in every industry, I think, so there were definitely some of those kids there, but the vast majority of us were there because we felt that's what we wanted to do, even if we didn't know what area of law we were going to go into. Mm-hmm. So I think for the ones who were there, just remember that there's a light at the end of the tunnel. And at the end of the day, all that matters is you graduate and pass the bar. So whether you went to Harvard Law School, Loyola Law School, or Thomas Jefferson School of Law or some other school of law. Like, if your goal is to be an attorney and you have a desire to do whatever it is you want to do, whether it's entertainment law, business law, sports law, like once upon a time, I thought I was going to be an agent, and I just kind of ended up pivoting into something else, Mm-hmm. But whatever it is that dream that you had, or that you have that compelled you to go to law school, just don't lose sight of that, because, it can get overwhelming at times. It can feel like this is never going to end. It can feel like the work is difficult. And I just think at the end of the day, what really sustains us in any endeavor is remembering what our purpose is and remembering what motivated us in the first place. So again, for those who are there is a light at the end of the tunnel. We've all been there. I was there at one point. Alan was there at one point. And just kind of keep your nose to the grindstone, because it kind of goes back to that whole grit idea, right? Mm. Angela Duckworth, I think is her name. She wrote that book, Grit. Mm. And it basically said that what really separates people isn't talent, but resilience. And so, we could all have a similar level of talent, or I might even be blessed with, more quote unquote talent or ability than somebody else. But if I don't have the grit and the determination and the resilience to really stick it out or see it through or master my craft, someone else with more grit and resilience is going to surpass me. Right. So I think sometimes, especially in law school, because, it can be, depending on where you go, kind of cutthroat or kind of, every man or woman for themselves. And then people kind of get caught up in that whole competitive aspect of, oh, this person's doing better than me, or I think this person's smarter than me. And they kind of, get discouraged or lose sight of what their actual goal or purpose is. So, I think just remember that, again, there's a light at the end of the tunnel. You have the resilience, you have the grit, you have the determination to stick it through, to graduate, to study for the bar, to pass the bar, because there's literally been, thousands or millions of people across the world, like not just in California, but in the, United States, that have all been in your position. They've all passed the bar and they've all gone on to, achieve great things. So I think that's my best piece of advice, is just to remember your purpose and your passion and what drives you in the first place, and then use that to kind of fuel that tank of your grit and your resilience, and, you'll be fine.
I love that. So you mentioned wanting to be originally a sports agent.
Yeah. So I think
How did that turn into personal injury?
I think that was more driven by when I was, in undergrad. Well, first of all, I grew up playing a lot of sports. Like I played baseball, I played football, I ran track. So I was always active. I always loved sports, and just kind of being, on the outside looking in as well as a fan. Mm-hmm. Like growing up in Los Angeles, or in Southern California in Los Angeles, I was always a Raiders fan, because when I was,
know which team that is.
They're now the Vegas Raiders of the NFL.
And they play.
They play in Vegas now. They play football. Yeah. Cool. They're a professional football team. So I have to give you a little bit of a sports education up here. Do you guys have the Jets?
Nope, they're New York now.
But aren't they?
We used to have the Nets, the Jets, and the Mets, and I remembered them because they all rhymed.
Yeah, the Meadowlands.
Well, yeah, but they're owned by, it's like the Brooklyn Nets and I forget who owns
the Jets.
Jets.
Woody Johnson, billionaire.
But I think they were also. I just know we lost all of our sports teams, and it's pretty classic New Jersey. It's okay. We have no sales tax. That's what we got going for us. Anyway, let's take it back. So sports. You wanted to be a sports agent. Why would you go to law school and become a sports agent?
Because a lot of agents, from what I understand, have legal degrees, and there's sports law classes that you can take in law school to familiarize yourself with sports law, because there's a lot of, contract negotiation. Mm-hmm. There's terms and issues that are specific to sports law that, if you want to be an agent, it would behoove you to learn about that stuff. And so, at Loyola, especially being in Los Angeles, they have, they had entertainment law classes, which I also took. I took a copyright law class just because I always loved music. I still love music to this day. And so just because, I have such a strong interest in music, I took a copyright law class just to understand copyright law, which was very, very complicated. So that dissuaded me a little bit from being an entertainment lawyer. Also, I think I even knew at that point that I didn't necessarily want to be like a transactional attorney and just like sitting in an office, reading contracts all day, negotiating terms, et cetera. So, having always played sports and had an athletic background when I was in undergrad at UCLA, I was like, oh, it might be cool to be an agent, just kind of thinking of it that way. Like, oh, being an agent sounds cool. And so.
But that's primarily transactional. It's mostly just
being an agent. Yeah. I mean, it's, what you would think of similar to like an agent in entertainment where, everybody, I think, well, from my generation, they picture Ari Gold from Entourage. Yep. Modeled on Ari Emanuel, I believe, and just like someone who's just on the phone 24/7, yelling into the phone, high energy, et cetera, et cetera. And so for me, like, I think, again, just because I had an interest in sports, I thought, well, being an agent might be cool. But then when I got to law school, it just kind of fell by the wayside. Like I wasn't really as interested once I actually got into law school and started doing the work and, started taking the classes. But big sports fan growing up. Like, when I was growing up, the Oakland the Oakland Raiders, or sorry, the Vegas Raiders now. They were here in Los Angeles. They were the LA Raiders, right? And they played at the Coliseum where the USC Trojans play. And so my family, that was our thing growing up. We would go as a family to LA Raider games and to USC Trojan games, which, I kind of ended up becoming a turncoat if you were to ask my brother and going to UCLA because he's still a diehard USC fan. And so then the LA Raiders ultimately went back to Oakland because the Oakland Raiders, that's where they started. Then they came to LA. Then their owner basically had a falling out with the commissioner of the NFL. They went back to Oakland, and then they went from Oakland to Vegas. And that's where they are now. But I'm still a diehard Raiders fan. When I first got to UCLA in '98, that was right when Kobe came to the Lakers. So it was the beginning of the Shaq and Kobe Lakers with Phil Jackson. My first year at UCLA, they won the first of their 3 championships in a row. And so I was never a huge basketball fan growing up, but it became easy to be a Lakers fan at that time because they were so good. They had arguably the 2 best players in the league in Shaquille O'Neal and Kobe Bryant. And they had arguably the best coach in the league in Phil Jackson. And so.
So what took you from sports to PI? Was it just the aspect of trial? Or was it, I guess, more because obviously PI and I guess could you dive into a little bit of what PI is and how that's covered when you're, I guess, kind of choosing your different practice?
Alan likes to say nobody ever goes to law school and thinks they're going to be a personal injury attorney, which is true because in law school there's no real personal injury class. So there's this area of law called torts, which basically tort means like a wrong that's committed against somebody, basically. Mm-hmm. So torts is kind of the equivalent of personal injury because in personal injury cases, the crux of all these cases essentially is negligence. So negligence means somebody did something they shouldn't have done. So there's a duty, a breach, and a causation. The breach of the duty is the negligence. So the duty might be that we as drivers on the streets all have a duty to drive as a reasonable and prudent person. That's basically the negligence standard, reasonable and prudent. So if somebody breaches that duty, that's the negligence. So if I'm driving and as I'm driving, I'm texting and I'm not paying attention and boom, I rear end somebody. I had a duty to drive as a reasonable and prudent person. I wasn't doing it because I was texting and then I rear end somebody. Mm-hmm. So the rear ending that's what the breach is. That's what the negligence is. And then as a result of my negligence, somebody gets injured. So duty, breach, causation, meaning I caused the injuries, right? And so in torts, in law school, that's what you learn about. Torts. So in law school, first year, we all took the same classes because in law school, there's a select curriculum that you take like your first year and your second year or part of your second year, which are like the core classes, because those are the classes, those are the areas of law that are going to be covered on the bar exam. And so every law school, they want to ensure as much as they can that their graduates are going to pass the bar because that raises their rankings in like U.S. News and World Report, which used to be a huge thing. I think it's less so now. Mm. But there's still, law school rankings and all these schools care about their rankings because that's how they attract students. And if they keep their bar passage rate high, that's also how they attract students, et cetera. So your first year and a half, everybody's taking the same classes. So like at Loyola, I was in section 1. So they had 4 sections. The first 3 sections were the day sections, and then section 4 was the night section. And so the incoming student body, they divided into 3 sections, and then whatever section you're in, you take all those classes with the same people. So me and Alan were actually in section 1, as was Bill. And so we all met in section 1. We all took the same classes. So torts is one of those required classes. So whether you think you're going into personal injury law or not, you're going to take torts because torts is one of those areas of law that goes back, many, many, many years to like the founding of the civil justice system in England. And so, because tort is, I think it's a Latin word, right? So there's so much Latin in law because it all goes back to, Old French and Old English and those civil justice systems when they first got started, et cetera. So when I was in law school, I took torts class, never really thought I was going to be a personal injury attorney. Alan didn't either. Like, no one ever thinks they're going to do PI law. And so we all graduated, passed the bar. Alan already had a business that he was in with his family that was not law related. So even though he graduated and passed the bar, he was already working in his family's business. So he stayed working in that business. And then me, I kind of had, no real idea of what I wanted to do, because having taken a whole bunch of classes in law school, there's nothing that really like jumped out at me. Like, I really want to do this. I'm passionate about this. This is where I think my purpose lies, et cetera. And so I kind of just started sending out resumes and seeing, what kind of interviews I could get and what my job prospects were. And so my first job, actually, I ended up working at this firm downtown called Quinn Emanuel, which I believe is still around to this day, but it's a like an intellectual property
Oh, that's cool.
firm. Yeah. And so I got a job as a contract attorney, not an associate attorney. So a contract attorney means they paid me by the hour
Right.
to just basically do document review. So I'd sit in front of a computer, and there was this big electronic database full of documents, and I would just review documents with this program that they had, and I would highlight documents and code them for attorney-client privilege or work product, or if it was a document that I felt was super relevant to the case I was working on. I remember they had this one code called hot doc, because it would be like a hot doc, and like they would want to know about it. And so if you tag something as a hot doc, like I think it went into like this special database, and like somebody else would review it or whatever. Because the lawsuit that I was working on, it was actually it was a lawsuit that involved chipsets, that's the hardware that's inside a cell phone. They called it chipsets. And so, this was in like 2005. So cell phones were much less sophisticated than they are now. We still had like flip phones and like clamshell phones and stuff like that. So like the hardware that they actually put in those phones was called chipsets. And there was this big lawsuit going on back and forth between Qualcomm and Broadcom. So a lot of the younger audience out there probably doesn't even remember Qualcomm
I'm still
and
stuck on
Broadcom.
clamshell phones.
Yeah. So Qualcomm actually had the patent on putting chipsets in cell phones. And so they were like the biggest, I think, chipset manufacturer probably in the world at that time. You guys can go fact check this on your own, disclaimer. And so they basically had a monopoly on chipsets. And then Broadcom, this other company, said, we want to make chipsets too. And I think the allegation by Qualcomm to Broadcom was that Broadcom had reverse engineered Qualcomm's technology and then started making their own chipsets. So basically like taking a cell phone, took it apart, looked at the chipset, figured out how to do it, and started manufacturing their own chipsets.
So is that copyright infringement?
Well, Broadcom, that's what Qualcomm was alleged,
Right.
like patent infringement.
Right. Okay.
Because patent
Right.
is what pertains to like actual, hardware and something like that. And so Qualcomm was alleging patent infringement, but then Broadcom was alleging antitrust, from what I remember, against
Okay.
Qualcomm, because they were like, you can't have a monopoly
Yep.
on making chipsets because this is a free market system, ostensibly. We should be allowed to also make chipsets and sell them. And so that's what this litigation was back and forth. And so I was just looking at all these documents between Qualcomm and Broadcom and, things pertaining to that litigation. And I would just review them every day and get paid by the hour. And so the money was actually pretty good, but it just got boring. And so, I got kind of restless and I started sending out resumes. And eventually I got an interview with this plaintiff side employment law firm. So I knew nothing about employment law.
And for people that don't know anything about law at all, plaintiff is who in the courtroom?
The plaintiff is in a civil lawsuit. The plaintiff is a person who's filing the lawsuit,
Okay.
alleging that the defendant has wronged them somehow. So going back to my, car collision example, if I'm driving, I'm being negligent, texting, and I hit somebody, I would be the defendant,
Right. And
because I'm the
person
one who
hit-
committed
yeah,
the wrong. And then the person who I hit, if they choose to file a lawsuit,
would be the plaintiff.
they would be the plaintiff, and then they would be suing me for negligence, basically.
Gotcha.
So in an employment law context, on the plaintiff side, the allegation is, so I'll backtrack. What I ended up doing at this firm was employment law, which encompassed at this firm uh, mainly wrongful termination. So in the state of California, there's a law known as the Fair Employment and Housing Act. And under the Fair Employment and Housing Act, it defines what are known as protected classes or protected categories. So it could be age, race, gender, sexual
Right.
orientation, et cetera. And so the allegation in a lot of our wrongful termination cases that we were handling at that time would be that somebody got fired because they were a member of a protected class. So they would be like, I believe my employer terminated me
On the
because I'm
basis
black,
of,
because I
yeah.
got pregnant, because I told them I have cancer, et cetera. And because those are protected categories and you can't fire somebody who's in a protected category because of that category, that constitutes wrongful termination or, any adverse employment action. So that could be a demotion or wrongful termination or anything else that constitutes an adverse employment action. So we were handling those cases. Also, hostile work environment cases, which would be what people would think of as like sexual harassment typically. So we were handling those types of cases on the wrongful termination side. And then there's also what's known as labor law cases, which would be in this context, people who are not getting paid proper minimum wage,
Right.
not getting paid proper overtime. They're
Right.
at that time, like their managers might be improperly taking their tips, like so improper tip pooling. That also constitutes wage and hour.
So how
law.
did the case, like, how did you get cases in employment law? Was that
So when I worked at the employment law firm, I was just an associate attorney.
Right.
So there were two partners. They were responsible for bringing in the cases, however they brought them in. And then they would just, sign up cases. And it was me and one other associate attorney, this guy named Jordan. And that's really where I learned like civil litigation practice because I would get assigned cases. And then Jordan had already been there when I got hired. And he would to this day, I give that guy credit for a lot of what he taught me about civil litigation, practice, the partners as well. But because I shared an office with Jordan and I had no experience in civil litigation, he was, amazing about answering questions, telling me where to find answers, showing me templates for how to do things, et cetera. So that's where I really learned the civil litigation process, especially what we call written discovery, because when we file a lawsuit, and then we serve the lawsuit on the other side. They file an answer. The case is what we call at issue, which means we filed a lawsuit against, X defendant. X defendant filed an answer. So now that defendant is in the case. Now the case is at issue. So once the case is at issue, we can serve written discovery, which are just basically written questions the other side has to answer about the case. They can serve written questions on us, so it goes both ways. We can send document requests, so requests for any documents that we think are relevant to the case. Same thing. They can serve us document requests. We can take depositions. They can take our clients' depositions. So all this stuff is the discovery process is like the fact-finding part of the case. And so when I was working at that employment law firm, that's really where I became familiarized with the civil litigation process in that sense, because I had no idea about any of this stuff, how civil litigation works, et cetera. And so that was really a very cool experience. I learned a lot. There was a steep learning curve, but I learned a lot in a short amount of time. And the cases were also very compelling in the sense that that's really where I got my first taste of representing people and getting a chance to stand up on behalf of somebody who, in these cases, they were alleging that, my employer, they fired me because I got injured on the job. So disability discrimination in the employment context that was probably the majority of the employment law cases that we handled because that happens all the time. So
was there a majority of industry that was happening in?
No, it really just ran the spectrum, right?
Wow.
And so it's a little bit different from workers' compensation because workers' compensation is, let's say I'm working I'm some sort of industrial machinist. Like I work
Right.
with a big machine, something happens, and let's say, my thumb gets crushed by a machine. If I get injured on the job, that's workers' compensation, which means there's a whole workers' compensation system. They call it the WCAB, the Workers' Compensation Appeals Board, that's separate and apart from civil litigation. So if I get injured on the job, my only recourse in terms of getting benefits, they also offer treatment. I don't have to treat through workers' compensation, but I can. But in terms of getting benefits, I can get treatment through workers' comp. All that gets handled through the Workers' Compensation Appeals Board. But let's say I get injured on the job and then, my employer knows that I got injured because it happened on the job. If they then take an adverse employment action against me, like they terminate me, now I might have a civil litigation suit because workers' compensation, the WCAB doesn't really handle like wrongful termination claims. That's really the province of civil litigation. So if I get injured on the job and my employer knows I got injured on the job and they then terminate me, I might have a wrongful termination claim in a civil litigation context.
Before we move on, can you give a few examples? Because I feel like, especially when I hear like employer, like I feel like when I hear these very ephemeral terms, I can't really picture who these people are or what's happening. Like, what were without being specific, I guess, but like, what were the kinds of people or the kinds of things that were happening that were getting, them wrongfully terminated?
I mean, it doesn't even have to be an on-the-job injury. It could be that, let's say I was just like, I might work for Starbucks, for example, and then over the weekend I was playing in like a pickup basketball game, and then let's say I broke my ankle, and now, I had surgery. The doctor says, I can walk, but I can't be standing for more than 30 minutes at a time.
Right.
I can't do heavy lifting. I can't do certain physical activities. Some of those physical activities, like if I get a doctor's note from my job that spells out what I can and can't do, what my physical limitations are, like a lot of times we would see things like no pulling, pushing, lifting more than 15 pounds, no standing more than 30 minutes at a time without having to take a seat, things like that.
So then obviously the wrongful termination is when Starbucks fires them, but what is the thing that's supposed to happen then?
So if let's say I have this injury to my ankle, I have a doctor's note, I take the doctor's note to my manager at Starbucks and say, this happened, I had surgery, these are what my limitations are. Under that same Fair Employment and Housing Act, there's a code section that says your employer, if you tell them you're injured and you have limitations, they have to engage in what's known as an interactive like accommodation process or an interactive process to determine a reasonable accommodation. So they're required to go through this interactive process with you, talk about what your limitations are, figure out if you can do your job with some sort of reasonable accommodation, or if you can't, if there's some other job you can do that, because doing some other job might constitute the reasonable accommodation. Like maybe we have some desk job in the back where you can sit the whole time, type in a computer, and that can be a reasonable accommodation for the length of time that you have these job restrictions. But a lot of times what happens is people will go to their employers, they'll give them the note, their employer doesn't go through an interactive process with them, just says, okay, thank you for the note, we'll get back to you. And then X amount of time later, they'll take some sort of reason or some sort of adverse employment action. Like they might terminate the person, they might place them off work, they might demote them, but they'll fail to go through the actual interactive process with them and then take adverse employment action. So that's where, the legal action might lie.
Interesting.
And so, in these cases, a lot of times what would happen is somebody would have an injury and then the employer would say, okay, we'll put you off work and you can't come back to work until you're 100% healed. So they would have a 100% healed policy, which is also impermissible under the law. So I haven't done employment law in a long time. Like I was doing employment law back in this was like 08, 09. And so this is what, what the law was back then. I don't imagine it's changed much, but these were a lot of the issues that we were dealing with at that time. Like people would come to us and say, my employer said I can't come back until I'm 100% healed, which is not permissible. Like they have to go through an interactive process with you. So
Wow.
depending on how physical your job is, there are defenses an employer can raise, like business necessity. Like we can't afford to not have you in this position because you're so integral to this
Right.
position. The fact that you can't do it, like we have to bring somebody else in to do your job because we can't afford to be without you. And so it's like business necessity, like undue burden is another employer defense. But like in those situations, the burden would be on the employer to substantiate those. Like you would actually have to prove it's an undue burden for us not to have you in this position.
Right.
So we have to bring somebody else in to do it. So, employment law is actually very, very interesting. Like I enjoyed it because you get to fight for people. Like a lot of these people, they were long-term employees,
Right.
20, 25, 30 years. And then something happens to them and then their employer just summarily dismisses them. And so, these people who had these jobs are like, I was working for this place for 25, 30 years, 40. I gave my life to these people. And then something happens one time, like I get injured one time and they just kick me to the curb. Or oftentimes those longer term employees, they would get aged out because their employer would just be like, oh, they're not going to tell them this,
Right.
but the employer's like, this person's too old now. They're making too much money at this point. We can get rid of them and bring in somebody younger and cheaper. So of course they're not going to say that, which is why in employment law cases, a lot of times those cases were very circumstantial, meaning
Right.
your supervisor is not going to come in and say, hey, I'm
You're
firing
old.
you because you're black or
Right.
because you're a woman. They're going to say,
Right.
oh, we're going through a reduction in force. And so we're getting rid of some people and you're one of those people. But if it turns out there was no reduction, if it was a reduction in force of one and they only got rid of you, that tends to indicate that was a spurious reason, right? Like a false reason. So a lot of times in employment law, you kind of got to put pieces of the puzzle together to be able to prove the termination was for an improper reason. Because also in California, it's an at-will employment state. So your employer can fire you at any time for any reason, as long as it's a non-discriminatory reason, unless you have a contract. But the vast majority of people in the state of California, they're at-will employees. They don't have a contract for employment, right? Like if you're at Starbucks, you're not signing a contract that says Starbucks agrees to employ you for 5 years and blah, blah, blah. So you're at will. Because you as the employee can also leave at any time for any reason. You don't have to give notice as an employee. Like a lot of employees do as a courtesy, right? Like I'd like to give my employer 2 weeks notice or whatever, but it goes both ways. So, in employment law, oftentimes it's like you have to be Sherlock Holmes in the discovery process and like get the person's employee file, find out like have they had any write-ups that would lend to the employer's excuse that like we fired this person because they're a terrible employee. But then in discovery, if we get their employee file and it's spotless, that disproves that, So you got to put those pieces together to be able to prove that the termination or the demotion or adverse employment action was for a protected reason.
Interesting. All of that, I guess, is the kind of crux of what I really wanted to talk about, which is like, what was your Erin Brockovich moment, if you had one? And for those of you who have not seen Erin Brockovich, go watch it. I just saw it recently for the first time. It was very good. And I say this as someone who had I had no foundation about PI law, and I have seen this across my peers in my generation. And for context, I'm on that like Gen Z millennial cusp. Go 96. But I had seen the billboards, and there's a lot of, we'll kind of get into the stigma around PI, because I think more than anything, I find it fascinating why there is so much. And having done a lot of research, I can see a lot of it is purposeful. But what I found really cool about the Erin Brockovich story was it uses that stigma to then turn it all on its head and show, I think, this whole David versus Goliath concept that you and Alan talk about a lot, which is, what is the average person's, right when corporations do them wrong? And that's sort of what my take on PI law really is.
Yeah.
And I think we get wrapped up in the billboards, the cheesy commercials, the car accidents. There's so much, and we see that in that film in and of itself. But I guess my question to you is, what was your Aaron Brockovich moment that made you want to be an advocate for, the average person?
I think to start, based on one of the things you said, personal injury law is like being a personal injury attorney. It's kind of like that phrase that people have about cops. Like everybody hates a cop until they need one.
Yep.
Everybody hates a PI attorney until they need one. Right. And so for me, I don't necessarily know that I had one Aaron Brockovich moment. I will say getting my experience at that employment law firm and learning about civil litigation and getting to represent people there. And then, so how Alan and I partnered up is he was working for his family's business, and this all kind of ties together. I was working at that employment law firm, and he called me up out of the blue one day. This was probably like late 2009 sometime, and was just like, "Hey, I think I want to branch out from working, with my family. I think I want to get into something else. How do you feel about partnering up and hanging out our own shingle?" And I was like, cool, let's do it. Because for me, also, like, I kind of always had the sense that I never wanted to work for somebody else long term. I just didn't really have a vision or an idea of how it was going to happen, that I was going to effectuate that plan, and I'm a big believer in everything happens for a reason. I'm a big believer in it's kind of that that thing from The Alchemist, the book by Paulo Coelho, I think is his name, where, it's a very popular book. And there's this idea in the book that when you kind of truly desire something and desire it for the right reasons, the whole universe conspires to bring it to fruition. So The Alchemist is just one of those kind of, it's one of those books about like finding your purpose, following your heart, trusting the universe, etc. And so at that time, I hadn't even read that book, to be honest with you. But I always just kind of had a sense that, as long as my heart is in the right place and I kind of follow what's in my heart and just take the steps forward, the path, I might not know where the path is going to lead, but it's going to take me to the right, place. And I might not always be able to see the path, but as long as I'm taking those steps and putting one foot in front of the other, the path will ultimately be revealed and I'll get to where I'm supposed to go. And so, when Alan called me up and we had that conversation, I was just like, yeah, let's do it. And, I had no experience running a business. Alan already had experience running a business just from working with his family, but I didn't have extensive experience practicing law as a civil attorney. And I didn't have that much money saved up. I had some saved up, but not a lot. And, with all that being said, we kind of agreed and we just took the plunge, And so I think we met at UCLA on campus like one time to come up with like a real kind of BS, business plan and, wrote some stuff out on paper and we're like, okay, this is good. Like after meeting for like a few hours and, we just said we're going to do it. And so we found some office space and, sublet it. And in the beginning, we were kind of taking anything that came through the door. Like we took like some lemon law cases, like a bankruptcy case, which I knew nothing about bankruptcy, personal injury cases. I was still taking employment law cases at that time. And just kind of being just the two of us as well. And like we had some mentors and we had reference guides and reference materials that we found and read about personal injury law, specifically about civil procedure. We really just immersed ourselves in that stuff. Like we were in the office all the time, basically like 24/7, 365, just reading and learning so we could just figure out how to practice law, right? Because when we first partnered up, I had never even taken a deposition, And so just kind of like that, almost like that startup, mentality.
Yeah, that's what it sounds like.
And, just kind of us against the world, doing everything from A to Z, fielding intake calls and signing up clients and filing lawsuits, et cetera. And I think
and now 15 years later, I mean, you guys are like doing massive trial litigation.
Yeah. So we went from just the two of us to, roughly 100 employees.
Yeah.
So, but during that time, I think as the cases came in and we would talk to the clients and get to know them and listen to their stories, it really gave us, it was very rewarding to know that we were helping people and assisting people in some of the most trying times of their lives and in a situation where they wouldn't know what to do or who to turn to. And oftentimes they're turning to us without knowing us from Adam. Like they don't know anything about us. So they're putting their faith and their trust in us without even knowing them or without them knowing us. And so for us, that was also very important because we always felt we had to do right by them, And I think one of the things that's really sustained us to this point is we've never lost sight of the fact that we're here to serve our clients, even to our own detriment at times in terms of, making sure that when the case resolves, they're getting, they're happy with what they're receiving. They're happy with the service they receive. They're happy with the outcome. And, there's been times where we would take less money in terms of attorney's fees in order for them to get more money, just to make sure that they're happy with the process. And, it might be a situation where there's only a finite amount of money to go around because, I think that's one of the misconceptions is that there's like an unlimited amount of money in any particular case. Like these cases are really driven by insurance and the amount of insurance that's available to compensate somebody. So, we've had cases where somebody might have a very grievous injury or it could even be a wrongful death case, but it might be a minimum insurance policy, which, in the state of California for a long time in terms of auto insurance, the minimum you're required to have in bodily injury coverage was $15,000. And so that recently went up to $30,000. But what that means is the reason why you have insurance, it's called bodily injury coverage, right? And so the reason you have insurance is because unfortunately, if I am driving and I'm not paying attention and I'm texting and I rear end somebody, my insurance covers the bodily injury I might cause to that person. So, if you think about if I'm doing something that causes the death of somebody, but I have a minimum insurance policy, then obviously there's no amount of money that can compensate, a family for the loss of a loved one or can substitute for the loss of a life. But in that situation, there might only be a $15,000 policy. So in situations like that, like me and Alan are going to do whatever we can to ensure the client gets as much money from that $15,000, policy as possible, because it's not about the attorney's fees. It's about the fact that somebody lost their life, unfortunately, and there's only a finite amount of money to go around. And we'll investigate to see if there's maybe some other angle where there's some other, compensation or insurance money that we can pursue. But if at the end of the day, there's only $15,000, like we have to ensure that, the client is going to get as much of that as possible. And so, for us, again, when we first started out, just really, talking to our clients, getting to know them, because we were the ones who were handling the files, So talking to our clients, getting to know them, understanding what they've been through, what they've lost, how this has impacted them, like that really kind of laid the foundation for what it is that, we do as a firm to this day. And I think for each of us individually, we had our own, kind of motivation for wanting to help people. But I think for the both of us, it was something that was innate because we never had a conversation in the beginning of like, this is what our firm ethos is, or like, this is what our values are. This is what we're passionate about. Like, not really in depth. It was just something that was very natural. And I think that's probably what, bonded us together in some ways as friends to that point as well, because we met in 2002, we partnered up in 2010, and we've been together since then. So, 20 years at this point that we've known each other,
Right.
over 20 years. And so I think just innately, we both kind of, from our own personal journeys, like we had things within us and from our personal experience that said, we have to stand up against corporations or insurance companies or just
Yeah.
large entities that might try to run roughshod over people or bully people. Like, I know Alan's had that experience, which, hopefully one day he'll come on as a guest and he can talk about that, himself, because that's
Yeah.
his story to tell. It's not my story to tell. And, I don't like if he wants to share, some of his perspective, he can. But again, that's his story to tell and not my story to tell. But for me, I think a lot of my worldview and how I feel about things and how I see things is just shaped by, growing up the son of two Black parents who grew up in the Deep South in the 40s, 50s, and 60s in the Jim Crow South, and also me just growing up as a Black man in America. And so I see things through that lens. And a lot of how I feel about society writ large, about, large entities trying to take advantage of people or not give people a voice or quiet someone's voice, it comes from that perspective because, my dad was born in Alabama in 1940. My mom was born in Mississippi, and Alabama and Mississippi historically are two of the most racist states in America and in the South, in the Deep South. And so their experience and me talking to them about their experience, especially, later in life, as I got older and I got more experience as an adult Black male in America, and then talking to my parents about their experience growing up in the Deep South in America, that's also really shaped my kind of societal, view of the U.S. and my worldview, because Black people historically in America, we've had, the government's foot on our neck in a lot of ways, even to this day, metaphorically and literally. And so a lot of how I feel and what my approach, to my cases and the people we represent, like it comes from that perspective of, I'm going to fight on behalf of you and for you because you wouldn't have the ability or the knowledge or the means to be able to do that yourself. And you have a righteous case. And I have to make sure I can do whatever I can to ensure you get the fairest, most just compensation you possibly can. And oftentimes in our cases, there is no amount of money that can compensate somebody for even the loss of their health, let alone the loss of a family member or a loved one. And the way I see it, and in my experience, the insurance companies and the corporations on the other side are trying to undervalue our cases and in that way take advantage of people by not offering them fair compensation, especially if an attorney isn't involved. Because we've seen that a lot of times too, like people, they'll get involved in a car collision, let's say, and then the other driver's insurance company will reach out to them and try to settle their claim really fast for nuisance value because they're trying to limit their exposure, save the insurance company money, et cetera. And so for me, historically with what's happened to Black people in America, I think that's something that's just kind of woven into my DNA and my lineage. And that's really kind of internally what motivates me, at least in part, to do what I do and to stand up for people really in any capacity. It's just that, I happen to do it as a personal injury attorney, but how I feel and, my belief system extends beyond that. But I get to employ it in this context. And who knows, maybe, somewhere down the line, I'll get to employ it in a different context. But for right now, I get to employ it in this context. And it's really, an honor and a privilege to be able to represent people who have put their trust in you and are looking to you to get justice on their behalf.
Before we touch on some of these larger cases, I wanted to just ask, how have you seen with your clients, because there aren't as many Black attorneys, do you feel like there is this just added layer of like when your clients come to you, that they're excited to feel seen and represented in a way that they maybe wouldn't? Does that happen a lot?
I think so, because, as you know, we have a very diverse office, and we do have a diverse clientele, but we have a lot of clients that, that look like me. We have a lot of Hispanic clients, and we have a very large, Hispanic employee base, and I think it helps our clients feel comfortable, and it helps our clients feel like they're getting representation from people and by people who really understand them, and the law is one of those industries historically that's been, basically an old boys club, like an old white boys club, and so for me and Alan, I think that's something that we take a lot of pride in as well, is, not being the norm and kind of bucking the system and bucking the trend in that regard, and really building out a firm that's extremely diverse, that represents a diverse clientele and a diverse population, because America is diverse, right? Yeah. America is a melting pot. And ostensibly, that's one of the principles that the nation was founded on as well, right? Like, if you look at the Statue of Liberty, I think it says bring us your tired, your hungry, your poor, your huddled masses, right? On the Statue of Liberty. And that's one of those iconic landmarks in America that people point to and say, wow, look at the Statue of Liberty. If you make it in America, you can make it anywhere, right? People still have that American dream that you can come to America, even from other countries, and still pull yourself up by your bootstraps and succeed. And so with that being the case, first of all, we're a testament to that. I think our firm and, me and Alan, and being able to build a successful business in America. So there are a lot of great things about this country, right? And the fact that we can build a business and build this diverse business and have this diverse clientele and this diverse, employee base, that's beautiful and it's amazing. But at the same time, we can't ignore the fact that there are still societal, systems in place, and there's a historical underpinning in our society of taking advantage of those same poor, tired, hungry, huddled masses, right? And so those are the people that we take a lot of pride in representing, right? We take pride in representing everyone, but also being able to be a firm where everybody can come and find, equal representation under the law, and find a firm that's going to go to the mat for them and really care about them. Because I think that's a big differentiator for us, is how much we care about our clients. It starts from the top. It starts with me and Alan, and hopefully there's a trickle down effect to everybody, we employ. But, in terms of our clients, I think they do appreciate being able to come to a firm where they can see themselves reflected in the mirror. I think that's important, and especially because if you look at the bar statistics every single year in terms of so they'll put out demographic statistics of what comprises demographically the current composition of attorneys in the state of California, right? And of course, white males are always the largest percentage, but then Black males and Black females are consistently the lowest percentage, And so for me, I take extra pride in the fact that, I'm a co-partner and co-founder in a successful personal injury law firm, because first of all, there's just not a lot of Black attorneys, period, in the state of California, and we're dwarfed by every other demographic. So, for me to be able to kind of, be a principal in a personal injury law firm that's as successful as, we've become, in large part due to that grit and resilience that I talked about earlier. Because, in the beginning, this is for anyone who's thinking of, being an entrepreneur, solopreneur. There's a lot of ups and downs, but there's way more downs than ups, especially in the beginning. So you have to have grit and resilience, but you have to also know what your purpose is and your passion, to let that be your guiding light, because that's what's going to sustain, that resilience. But again, and I know for, Alan, being in his position, being a principal of a, personal injury law firm, he has a lot of pride in that as well. And we take a lot of pride in being kind of outside the norm in terms of that, old white boys club.
Yeah. I like that. So I think, Chris, I'm guessing we need to wrap up.
I'd say to keep it.
Okay. Okay. So I think I want to turn lastly. Yeah. I think taking that theme and just zooming out a little bit to I think ultimately destigmatize. I know we're going to have to zoom a little bit quickly through, I think, why PI has such a bad rap. A lot of it came from the 70s tort reform that we can briefly touch on. But when we look at some of these big cases that, are just these massive settlements, right? There's a few things that stick out to me about why they're so famous, right? They're these billion-dollar settlements. They're against huge companies. And it often looks like a, maybe lower income person trying to get something from a company. We've invented a really big narrative around, people trying to not get hurt on purpose, but that there's like an angle, right, that's nefarious on the part of the plaintiff, not the defendant, not this, billion-dollar corporation. Where does this narrative, or what are some of the pieces of this narrative, right? Like when we think about the McDonald's case or the PG&E case or the Ford Pinto case, right? Why are the people that have suffered coming out looking like or even the attorneys helping them get the case? Why is this side not looking good in terms of our cultural narrative around PI, and these corporations that have injected chemicals into the ground or actively made a car that they knew would explode? Like, why are these companies not necessarily taking all of the heat for this, constant battle, this David Goliath match?
I think that question is it's a big question that has a lot of different parts that go into how this monster was created. You mentioned tort reform. So I think tort reform is a big part of it, because that tort reform dates back to around the 70s, let's say. And so what really happened with the tort reform was that, kind of long story short, there were doctors who were complaining that medical malpractice lawsuits were causing the doctor's insurance premiums to go up. So then, because first of all, in America, everything is about lobbying, right? So we have a political system, because that's why I also said, like, there's a lot of moving parts to this answer, but we have a political system that's really predicated on lobbying and large corporate interests. And we're moving, scarily, in my opinion, I think even more in that direction in terms of like corporate oligarchy, et cetera. So, but even back then in the 70s, right, it was like lobbying in America, especially in recent politics, has always been a big thing. And so, doctors have a much larger lobby than personal injury attorneys, and so doctors were basically able to, with the assistance of lobbying, create this narrative that personal injury attorneys, these are all like blood-sucking vampires that are, driving around in Ferraris. They're, damaging the civil justice system, et cetera. And
Is that where ambulance chasing came from that era, or is that more recent?
I think probably, like we could do a deep dive into the origins of that term specifically, but I think tort reform
of ambulance chasing, 1890.
By the what?
He was in The Sun. I think
Oh,
Must
the
have been
Sun. New
Leah,
York.
yeah.
New York was the earliest.
Wow.
Wow. So
It's so embedded.
yeah.
I mean, how do you get rid of 100+ years of a?
Well, I think, if we want to take it back to 1890, then we're going all the way back to like what they call, I think, yellow journalism,
Yep.
which is basically like the beginning of the tabloid era, right? So, and I think because they were printed on yellow newspaper, that's why they called it yellow journalism. But like yellow journalism was kind of the predecessor to tabloid journalism. So even back then in the 1800s and 1890s, they're probably printing these stories that were designed to get some sort of reaction
Yeah.
from the readership or craft
OG
some sort of
clickbait.
narrative. Yeah, it's just
Yeah.
like early clickbait, right? And so then when tort reform came along, that's really where you saw a nationwide campaign to vilify personal injury attorneys that's kind of persisted to this day because there was
Because it's happening
advertising
again
to that.
now.
Yeah. And there was advertising to that effect, which there's advertising to that effect today, right? And
Yeah.
so in terms of like diagnosing this problem or how it came to be, I think you also have to, in that pot, add in programming, right? And
Right.
media programming, because everything is programming. What you watch on TV, what you listen to on the radio, what you see in movies, like that's all programming. And so even when you watch a movie and you see the plaintiff's attorney that's portrayed a certain way, or see a TV show where the plaintiff's attorney
Right.
is portrayed a certain way, like Suits, for example, which kind of got a second wind on Netflix, right? Like it
Yeah.
went crazy on Netflix to a younger generation who had no idea what that show is even about. But like, what's the guy's name? Harvey Specter, right?
Yeah.
Like people think that's what attorneys are, what corporate attorneys are, what personal injury attorneys are, just like somebody very slick in a tailored suit with a fast mouth who's essentially like a fixer or whatever,
Right.
And so I think a lot of the perception of attorneys in general and personal injury attorneys also has to do with the media and media portrayals of attorneys. And so once you kind of get that programming going, it's like a snowball that's going downhill that gets bigger and bigger and bigger and bigger. So for us, the personal injury attorneys who are actually handling cases, and we see what it's like doing this job, and we see how the quote unquote sausage is made. Like I think if people really saw what being a plaintiff personal injury attorney is like, how we approach our clients, how we approach our files, like what we're trying to do in terms of fighting for justice for people, they would have a different perception.
I think that's what I really loved about hearing, and again, not to plug Aaron Brockovich, but something that Adamson Ahdoot does that not every PI firm does, but you guys do go to. Oh, that's my alarm. You guys do go to trial, and so you take on cases that require investigation, and this is something I didn't know about. Because a lot of firms some firms turn down cases like that because they're so expensive.
Yeah.
Right. Because you need to hire expert witnesses. You need to, spend your own time and work hours, right, diving into whatever that I know one of your attorneys had a case on lithium ion battery explosions. So, right, you need to familiarize yourself with industries you don't know anything about to be able to effectively narrate a plaintiff's side. And that takes expertise, right? There's so much
It takes
more
money, right?
Yeah,
Because
a
we're
lot of
working on
money.
contingency. So I think that's another thing that maybe people don't understand is that we're taking cases on contingencies.
Which goes into today's, right, there is a lobbying push now to lower and cap attorneys' fees, right? Which a lot of people, at least my perception of attorneys going into, from what I saw in Suits was your billable hours, right? Was your you can't afford my hourly rate.
Yeah.
I'm X amount of whatever. And so contingency is something that is mostly common to
personal
injury.
law.
And then occasionally I've seen it in entertainment law, or they'll get a percentage of the deal. And then is it true in employment law at all, or is that also
employment law
hourly?
cases were also on contingency,
Okay.
but employment law, you can also get attorney's fees.
Right.
So, in our cases, we get attorney's fees as a percentage of the settlement. But in employment law cases, if you take a case all the way to trial and get a verdict, you can also make a motion for attorney's fees where the court can potentially award attorney's fees, because the idea is that in order for you to take this case and prosecute it all the way to trial, there were other cases you had to turn down. There was other work that you couldn't do, et cetera. So in order to kind of, reward you for taking this case and spending all this time and energy and effort and money on this case, you can now make a motion for attorney's fees where you can submit like an estimate of you can keep track of the hours that you work on in employment law cases and then submit those
But the
hours
other side has to pay
with
that.
a fee.
Yeah.
Yeah, the other side has
Right.
to pay.
Right.
Yeah. So in personal injury law, it's not like that. Like the attorney's fees that we get are just a percentage of the settlement or the verdict.
Right.
There's no statutory attorney's fees that we can get, but that's like getting into the weeds a little bit. But for us, because we're on contingency, as these cases go along, it still requires money that we have to expend, as you mentioned, in order to
Right.
prosecute the case. Like we have to hire experts. We have to, pay investigative costs in certain cases. There's filing fees just to file a lawsuit. We have to pay
Right.
money to take depositions, et cetera. The
Or
client's
if
not
it's a
paying
government
that.
tort, there's often different expenses related with that.
There could be other expenses if it's a government claim, but like the big picture idea is that the client doesn't pay any of that.
Right.
We're paying that out of pocket.
Right.
And we have many, many, many cases. So it's not like we only have one case to worry about fronting costs on. We're fronting costs on a lot of cases
Right.
because we believe in the case and we believe that there's going to be a recovery at the end of the case. And so, but we're rolling the dice on every case,
Yeah.
because if that case goes sideways and we don't get a recovery, we have to eat that money. And, as you alluded to, in order to try a case, we might have to spend $200,000, $250,000 to try a case.
Right.
And so it's not like we're handling these cases like on a lark or the clients are paying money out of pocket to bankroll the cases. We're paying this money out of pocket. We're fronting these costs on contingency, And I think from the outside looking in, kind of getting back to your question, the statement that you made about caps on attorney's fees, like that's something that comes up periodically because that's also part of that tort reform narrative is that these guys are all out here getting rich. They're driving Ferraris because they're making all this money handling these cases. So we should cap their attorney's fees at X percentage, which like you don't see fees capped in any other industry. Like if America is allegedly like a free market system where whatever you're able to command in a free market is what you can get, why are we going to hamstring personal injury law specifically? Right. And it's only because
suspiciously targeted.
Exactly. And so if you think about you can see who's behind some of these initiatives. Like in the past, it's been like the Koch brothers. It's been, the tobacco industry or the automotive industry, or it's always an industry with an agenda. Like now it's Uber, and rideshare companies. Probably, I think Amazon has been involved in some of these efforts, right? So it's like, why would these corporations have such an interest in wanting to cap attorney's fees? It's because what they actually want to do is squeeze attorneys out of the market. So they want to make it so, not worthwhile or profitable to take these cases that people just stop practicing this law or just take these cases at like a much lower rate, because that's exactly what happened in medical malpractice, right? Like in response to tort reform, many, many, many states, including California, implemented caps on damages in medical malpractice cases. So now in medical malpractice cases, in terms of pain and suffering, like emotional distress, so like loss of enjoyment of life, anxiety, physical pain, mental suffering, et cetera, those damages are capped at, it used to be $250,000 in California. I think it went up a little bit recent, but for a long time, for 25, 30 years or something like that, pain and suffering was capped at $250,000. So no matter how bad your injury in a medical malpractice context, your pain and suffering was only worth $250,000. So what that did, unfortunately, was a lot of medical malpractice attorneys, they stopped handling those cases or handling them at such a high volume because
they didn't believe in
not because they didn't believe in them, but because you've artificially capped the damages. I can pursue, you can still get what we call economic damages, which means like past and future medical expenses. That's uncapped. But pain and suffering, which is a huge component of damages in any personal injury case because it's how it's affected you as a person, which
It's
could
the
be
personal part.
exponential. Yeah, it's the personal part. Those damages are capped. So now with these fee caps, proposed fee caps for personal injury cases writ large, like not just medical malpractice cases, these industries are trying to do the same thing because going back to something else you said initially, it's because they don't want to be held accountable.
Yeah.
So the province of personal injury law is to hold people, corporations, industries accountable when they refuse to be responsible.
Yeah.
This podcast is brought to you by Adamson Ahdoot, LLP. Hosted by Christopher Adamson. Produced by Lauren Henning and Chris Wigan. If you have thoughts or suggestions, email us at itspersonal@aa.law. The views, opinions, and statements expressed by guests on this podcast represent the personal perspectives of the individual speakers and do not constitute official positions of Adamson Ahdoot, LLP, or its attorneys, staff, or affiliates. Nothing discussed creates an attorney-client relationship, and the content is provided for general informational and educational purposes only. Always consult with a qualified attorney about your specific circumstances.